President Trump is calling on the Supreme Court to overturn DACA. The president says the Obama-era immigration program should never have happened and that the High Court should not let it stand. DACA is just one of the social issues the justices are considering this term. The court is set to hear arguments that could affect the 1973 Roe v. Wade decision legalizing abortion. Another case involves whether laws against sex discrimination prevent employers from firing gay or transgender workers. Also on the firing line, a case that could lead to an expansion of Second Amendment rights and the issue of the separation of church and state. Our Faith Nation team sat down with Thomas Jipping, a deputy director and senior legal fellow at the Heritage Foundation, to discuss the new term.
The Supreme Court has already addressed the issue that's involved with this particular state law, and that is a law that requires that abortion facilities have connections or relationships with hospitals. It's a pretty specific kind of regulation, and so I don't think it's one that will raise the broad issue of whether the Constitution protects the right to abortion. But there are many other kinds of regulations and restrictions being enacted, and perhaps one of those may have that potential.
Another case looks at whether the Civil Rights Act protects transgender and gay people from discrimination on the basis of sex. People opposing the expansion say that they're concerned that changing the law would have unintended consequences. Your thoughts there?
Well, I don't think that's the biggest issue. The issue in those three cases, two involving a gay employee and one involving a transgender employee, the real issue there really doesn't have anything to do with sexual orientation or gender identity. It has to do with whether, when judges interpret statutes, are they free to give those statutes new meaning, or do they have to stick with what Congress intended those statutes to mean when Congress passed them? When Congress enacted the Civil Rights Act in 1964, there is no way that they had sexual orientation and gender identity in mind when they prohibited sex discrimination. That's the only issue that really a judge ought to concern himself with, and that's the kind of standard that ought to be applied across the board, no matter what a statute is about.
On the gun issue, it's going to come up before the court for the first time since 2008. Excuse me. What do you expect to happen there?
Well, that's a challenge to a very restrictive gun law in New York City that prohibited essentially taking guns outside of the city for any purpose, whether even to a gun range, to practice shooting. The city has repealed that ordinance, and so one thing to watch is will the court still jump in and decide the underlying substantive issue, or will they say, since that law really is no longer on the books, we're going to take a pass? But it is a very restrictive law. The Supreme Court has said the Second Amendment protects an individual right to keep and bear arms. So if they do tackle that issue, I think it's very likely that they'll strike it down.
Real quickly here, how much do you think the makeup of the court will affect some of these decisions that we're expecting?
Well, when I think of the makeup of the court, I think of how many justices take the traditional view of what a court is supposed to do in deciding cases. Do they take the law as it is, as it's written, or do they think that they can make the law into whatever they want it to be? And I believe there's a majority of justices to take that traditional approach.
All right. Thomas Jipping with Heritage, thank you very much. Good to see you.
Thank you.